Hello and welcome to Rights and Recourse, a program that tackles constitutional, human rights and legal issues, bringing you information and analysis. My name is Dumila Mateza. Remember, you can also be part of our discussion today by calling our studio line on 011 714 5497 or 5498, or tweet us at Rights and Recourse. Alternatively, email your thoughts to rightsandrecourse@sabc.co.za. On Friday, September the 1st, Kenya's Supreme Court delivered a surprise judgment against the expectations of many. The court ruled in a 4-2 majority judgment that the presidential elections held on August the 8th was null and void. The incumbent Uhuru Kenyatta had been declared the winner of the poll. Justice John Maraga was widely expected to dismiss the election petition filed by the opposition candidate Raila Odinga after the poll against President Uhuru Kenyatta and the Independent Electoral and Boundaries Commission. The elections will now take place on October the 17th. In the light of this development today on Rights and Recourse, we examine the understanding of Kenya's constitutional democracy. But first, let us have a look at this insert.
A declaration is hereby issued that the presidential election held on 8th August 2017 was not conducted in accordance with the Constitution and the applicable law, rendering the declared results invalid, null, and void. Number 2, a declaration is hereby issued that the third respondent was not validly declared as the president-elect, and that the declaration is invalid, null, and void. Third, an order is hereby issued directing the first respondent to organize and conduct a fresh presidential election in strict conformity with the Constitution and the applicable election laws within 60 days of the determination under Article 143 of the Constitution.
Well, that is Chief Justice John Maraga of the of Kenya. To take us through, to discuss today's topic, we are joined in Kenya, in Nairobi, by Sarah Kimani, our correspondent there. And from our Cape Town studio, we're joined by retired Judge Johan Kriegler. From our Pretoria studio, we are joined by the chairperson of we are joined by Dr. Martin R. Rupia, Associate Professor, Institute for African Renaissance Studies at UNISA, and Mr. Grant Masterson of the Electoral Institute for Sustainable Democracy in Africa. Ladies and gentlemen, good afternoon and welcome to Rights and Recourse.
Thank you.
Sarah, let me start with you. Let us start with you. Can you give us a background of what is happening now post the Supreme Court judgment? Hello, Sarah, can you hear us? Well, whilst you're trying to get hold of Sarah on the line, I will try and find her from Grant. You were in Kenya and you saw what happened. What are the problems in Kenya really with these elections?
Well, Kenyan elections tend to be quite polarizing for a number of reasons. One of them is that there are very strong ethnic dimensions to the vote, that both of the main candidates draw their support primarily from a single ethnic group. And those ethnic groups make up the largest single ethnic groups in the country, so we tend to get quite ethnically polarizing election contests. The country has a history of post-election violence, which of course makes everyone quite concerned when you analyze an election and you evaluate the strengths and weaknesses of an election. Obviously, one of the key concerns is, will this election lead to post-election violence, which is, from anyone's perspective, obviously the least desirable outcome. And then, of course, for these elections, there was the introduction of new technologies in the way in which the vote was cast. There was a new electoral commission, which was sworn in only 7 months before the elections. And there were a raft of legal challenges around the processes leading to these elections themselves. 42 cases were brought before the courts in the months before the elections themselves. So this creates a very complex electoral environment within which these elections took place.
Dr. Rupia, if you can hear me down in Pretoria, up in Pretoria, the Kenyans in this case would seem to have woken up to the fact that their country, like South Africa, is a constitutional democracy since 2010. And that means the courts will always be arbiters in a dispute. We can't hear Dr. Rupia. I don't know whether Dr. Rupia, you can hear us. Well, we can't hear Dr. We seem to have a whole lot of gremlins in our system this morning. Let me try and find Sarah. Is Sarah back on the line? Sarah, can you give us a sense of what is happening in Kenya today leading to the rerun of the presidential elections? Hello, Sarah? No, she's not there. Okay, well, we'll continue here. I would like to go down to Cape Town. George Krichler, you handled South Africa's first elections in 1994. And probably you were confronted with much more, probably similar cases in South Africa. Can you give us a sense of what you think, what must have confronted the commission in Kenya?
I don't wish the job of an electoral commissioner in Kenya on my worst enemy. It's a very, very difficult job. It's politically very, very fraught with all sorts of tensions. The body politic, the general electorate in Kenya, is mistrustful of their elections. They have been for many years, and I'm afraid an electoral commission, a body that has to administer an election in a toxic climate like that, has an uphill battle. And I don't think they'll get that right for quite a while still.
The other thing, you mentioned earlier, Grant, that there's this toxicity of tribalism, but it was not as pronounced as many people made it up to be in these elections.
I think that's probably fair, yes. And whilst we still see tribalism play a key role in the politics of Kenya, I don't think that these elections and the problems around these elections in particular were tribally related. So I think that's a fair assessment. This election does seem to really come down to, in the Supreme Court's opinion, whether or not the processes that were stipulated ahead of the election were accurately and faithfully followed by the Electoral Commission prior to announcing the results of who had won the election and declaring a winner. So we really need to be having actually a procedural discussion rather than an ethnic or a tribal discussion in these elections, which I think in and of itself shows that Kenya is making progress, and although we seem to have arrived at a similar position in the aftermath of these elections, I think there are encouraging signs there, and that even Justice Krichler and the report that he made into the Kenyan electoral system has been partially adopted, and that there have been improvements made based on the recommendations in that report.
Let's go back to Pretoria. Dr. Rupia, if you can hear us this time, I don't know whether Dr. Rupia can hear us. Kenyans have woken up with this judgment to the fact that theirs is a constitutional democracy and the courts will always be arbiters in a dispute. Well, it seems to be, not to say, is Dr. Rupia there? No, we seem to have problems with that line once more again, but we shouldn't have problems with that line in particular. The other question is, I read a number of issues, Grant, where a number of reports in preparation for this discussion where it was said that the Supreme Court of Kenya has not given its reasons why it annulled the elections, and the commission would not know what to do. But I picked up a memo written by the chairperson of the commission, Mr. Wafula Chibukati, to his CEO, Mr. Chiluba, saying everything that is wrong with the elections.
Yeah, look, we do need to be careful here. As we sit and discuss this issue, I think it's very important and a very valuable discussion. We do need to recognize that the Supreme Court has ruled They've given their ruling, but they have not provided us with the reasons, the full reasons for their ruling in written form. So we are speculating at this stage. We can only go on their spoken judgment and really try and infer from that what their full judgment might look like. So we do need to be a bit cautious in extrapolating too far from the judgment itself. But this is a big problem for the IBC because the laws in Kenya require that an annulled election needs to be reheld within 60 days, which is an extremely tight time frame under even the best of circumstances. And here we sit with the clock is ticking and the judges are sitting on their judgment, and the IBC, I think, has quite fairly said, please expedite the written judgment so that we may see what the courts found was wrong with the first round election, so that when we rerun these elections, we can address those issues.
I just want to go back to something else. George Krichler down in Cape Town, we'll come back to you. One of the problems that somebody said to me that the judiciary in Kenya is actually on trial here. Is that the case?
I think the judiciary is always on trial in a critical constitutional issue such as a presidential election. Yes, it is on trial. I think it behaved with great restraint in very difficult circumstances, but I'm very, very keen to see what their reasons are, as the electoral management body must be very keen to see what the reasons are so that they can fix up what was found to have been fatally defective. You know, an election result has to be delivered quickly. That's politically necessary, otherwise tension rises. But at the same time, a judicial decision cannot be taken in a hurry. It calls for sound deliberation, consideration, research, rereading, rethinking, and the political and the judicial interests are in conflict with one another, and the Kenyan Supreme Court did its level best in this particular instance to meet that challenge, to announce a result, and we hope that it can give the reasons pretty soon.
Dr. Rupia, if you can hear me now, I'm told you can hear us. The Kenyans, it would seem, have woken up to the fact that their country, like South Africa, is a constitutional democracy. And that means the courts will always be the arbiters in the case of a dispute.
Your last comments then disappeared, so I'm...
Oh, it doesn't matter, but the fact of the matter is that Kenya is a constitutional democracy and the courts will always be arbiters in a dispute.
Yes, there are three players in this case, and the judiciary in Kenya, I think, played an important role in which any political party that is not satisfied with how the process has been conducted will then approach the courts, which Raila Odinga and his running mate did. What is emerging both from the court decision and also the leaked memo by Wafula, the chairman, that you referred to, is that there were certainly areas of flaws within the IEBC in how the election was conducted. 2 points. The first was the chairman, Wafula, was in fact admitting that his own password had been used more than 9,900 times by someone whom he did not know. And secondly, he also admitted that the IEBC had not received poll results from more than 569 polling stations. So you see inconsistencies that emerge in terms of the conduct of the election. Certainly now we go forward in the next 60 days. There's tension in the country, and my colleagues around the panel may also add some few details as to which way this country is going to go.
The issues for me are so complex, Grant, in that if you are saying, going back to my earlier question around the fact that some newspaper reports are talking about what is it that the commission is going to correct when the court has not released its full judgment and given reasons why it has annulled the elections. If you read this memo by Chebukati, the chairperson, It tells you exactly what went wrong. 595 polling stations failed or otherwise refused to send any results for the presidential elections.
Yeah. I mean, the process here has come under, I think, justifiable scrutiny. As an election observer, I would have a proviso here that just says that there is no such thing as a perfect election. Procedurally, if you look closely enough at any election, and no matter how well it's been regarded, you will find these type of procedural inconsistencies. And so where the courts come in is the courts are asked to adjudicate on these matters as to whether they feel the impact of the inconsistencies and the irregularities, and I think they even use the word illegalities, and that's, I think, we really need to see the judgment, which aspects of this process were followed illegally, because that's critical to our understanding of the judgment. But if you look at any election too closely, you will find them, and so the courts need to come up with a determination: did these inconsistencies materially impact on the elections to the point that we cannot have confidence? And so in this case, which is a landmark judgment in Africa, the Supreme Court has decided, yes, that these irregularities are so serious that we need to annul.
Let's go back to the question you raised. I want to ask Judge Kriegler this. You said no elections are perfect. And Judge Kriegler, I seem to remember you saying the same thing, that your elections in 1994 were not perfect, but you had to see to it that those elections continue.
Of course, they were far from perfect, but the electorate was prepared to accept them, and that is the crucial issue. The electorate in South Africa in 1994 was desperate for the elections to succeed. The electorate in Kenya in 2007, 2012, 2017 is very keen for the elections to remain a subject of great suspicion and rumour-mongering. The atmosphere, the political climate is crucial, and the climate in Kenya is toxic as far as elections are concerned. That's the issue that has to be addressed before you will have an election that will not be bedeviled by umpteen objections and complaints. And at the same time, I must agree with Grant, no election is perfect. And the difficult issue is to decide, are the imperfections so many and so serious as to have an effect or a probable effect on the outcome? That's what the Kenyan court decided. We don't know their reasons yet. And I agree with Grant, we shouldn't try to extrapolate too much what those reasons were. Let's see what they are once they've arrived, and we can then determine the extent of the job that the IEBC has to do a better job in October.
Dr. Rupia, I picked up an interview by John Kitongo with retired Chief Justice Dr. Willie Mutunga. Dr. Willie Mutunga is reported to have said, and I quote, "At the moment, I do not like the state of the country's preparedness for peaceful, fair and free elections. My decision to retire, in part, was aimed at triggering a national dialogue on this critical issue." What do you think he meant there?
My sense is that he acknowledged the deep divisions that characterize the Kenyan society. On the one hand, of course, we have the standard electoral structure and form and institutions. But if you look at the Kenyan society, you see historical differences, ethnic differences, and violence also characterizing the selection of leaderships. And so the next process that we go towards, I'm sure what he was intimating was that we would have a clear and an election that has integrity, in which the process can be interrogated and found to be transparent. Certainly the one that has just passed has failed that test of transparency and integrity, and that's what I think he meant.
Well, if you'd like to join us in today's discussion, you can call us on 011 714 5497 or 5490, to tweet us at Rights and Recourse. Alternatively, you can email your thoughts to rightsandrecourse@sabc.co.za. Stay with us.
What guides us? Is it something you can see?
We need deliverance from sin because God never
Hear?
carry on working to spread the message
Feel?
to the whole world.
Or touch? What leads us onto greater experiences? Is it the words of our sacred texts? The advice of our elders? Or is it the actions of our people? The strength of our beliefs? Or the voices of our citizens? Your country is guided by the voices of its people, and your broadcaster is dependent on your voice to guide it. Get your copy of the SABC's editorial policy and have your say.
This indeed is a very historic day for the people of Kenya and by extension for the people of the continent of Africa.
I personally disagree with the ruling that has been made today. But I respect it. I disagree with it because, as I have said, millions of Kenyans queued, made their choice, and 6 people have decided that they will go against the will of the people.
Well, there you heard from Raila Odinga, the leader of the opposition alliance, and from President Uhuru Kenyatta, their reaction to this judgment. President Uhuru Kenyatta using 2 words that are that are diametrically opposed to each other. I respect, I disagree, and I respect. What do you read from that?
Well, it's possible for those to be consistent in your views. He is obviously unhappy that the results which declared him president for the second time have been annulled. And he, like the rest of us, is waiting for the judgment in written form to understand those reasons. So he's obviously disappointed in his personal capacity, and he may even feel that there wasn't sufficient grounds. But I think that at this stage that would be pure speculation on anyone's part until we've seen their reasoning. And then, of course, the importance is he is still the sitting head of state, and it's very important for the head of a constitutional democracy like Kenya is to be seen to be respecting the constitution of his country. And so I think he was trying to walk a tightrope there, saying he was unhappy with the judgment, but he respects it.
Judge Kriegler, there's always going to be this issue between the state or the government and the judiciary, and we normally talk about the separation of powers doctrine. Could you explain that to us in this case?
In just a few words, the executive, the president, runs the country. Parliament, the legislature, makes the laws in accordance with which the president and his cabinet must run the country. The judiciary decides whether the president is in fact running the country in accordance with those laws and in accordance with the constitution. Each one of those 3 branches of the state operates in cooperation, but in competition and in balance with the other. That's what is meant by the separation of powers. Madiba in 1995 gave the perfect example when the Constitutional Court in South Africa issued a statement, a judgment, in which it declared that a proclamation of the President Mandela's, was invalid and therefore of no force or effect. He went on national radio and television within an hour. He said he was unhappy with the result, but as far as he and the government of South Africa is concerned, the law is what the Constitutional Court says it is, and it will follow it scrupulously. That is a recognition of the separation of powers.
Dr. Rupia, were the people of Kenya surprised by the reaction of President Uhuru Kenyatta after the Supreme Court ruled that there should be a rerun of the presidential elections in 60 days?
I'm sure your clips, Dumi, you could have also included the president on the same day contradicting himself and personally attacking the judiciary, which worried many of us as spectators and experts on the subject. So certainly not only are the institutions not cooperating, but I think he is also attacking the integrity of the judiciary in Kenya. And the Law Society and the Law Commission and several other independent bodies then came out strongly in support of the judiciary to say it is unfair for the president-elect to personalize and attack the persons of the people that had delivered this decision. So if we go forward, Africa's institutions and separation of powers still has to mature. Of course, we are learning great and good lessons from the contestation in Kenya, but the integrity of the judiciary certainly has been seriously questioned in the remarks that he then made publicly after leaving State House, or when he was just addressing his supporters well after this event.
Well, talking about the criticism from the judiciary and also the Law Society in Kenya, South Africa's Chief Justice Mogoeng, as president of the Conference for Constitutional Jurisdiction of Africa, has expressed concerns by President Uhuru Kenyatta's comments, and that has disrespected Kenya's judiciary, especially when you refer to the judges as crooks. Did you hear me there?
Yes, yes, I do. Certainly that is no complimentary description of the people that had ruled, not in your favor, but certainly because of their professionalism and the independence of the judiciary, their decision-making, as a majority, 6 out of 8, should have been, must be respected. We must even not say, should have. Going forward, it is also a standard practice for the judiciary to issue their conclusions and then promise to deliver in 2 weeks, in this case, their reasons for arriving, for the decisions that they did. So certainly going forward, some members of the judiciary may actually be deterred to maintain their professionalism and independence. But for now, we have to respect what is on the table, and certainly we have now seen that the institution of the IEBC itself still has some very serious work to do before they can also gain the confidence. In Kenya, we have seen a number of times the public getting on the streets and marching against what they see is the lack of confidence and independence and integrity of the IEBC. So the institutions are still in question in terms of how they are viewed by the society.
Judge Kriegler, the other question for me is something I think we have heard before in South Africa, where the president is saying 4 members of the judiciary taking a decision to annul what the people have chosen. We've heard that before, isn't it?
Yes, we'll hear it again. Politicians are human beings. They're not saints. They're not angels. But the judiciary is aware of that, and it is not a babe in arms. Our judiciary and the Kenyan judiciary has its constitutional foundation. It's got its job. It will continue to function. It will continue to decide what the law says, what the Constitution says, and whether executive action is in compliance with it. Occasional conflicts, occasional criticism, one must expect. We don't live in a perfect world. Essentially, however, I think Kenya has turned the corner. It's adopted a new constitution. It's got a brand new, ostensibly legitimate judiciary, and I think it will get over this hiccup in due course.
There is a small article, grant written by one Odomaro Mubangizi, which simply asks the question, where is Form 34A and Form B34, Form B34A and Form B and Form 34B?
Yes.
What does it mean by that? What are these forms?
Right, so this is, as we understand it, without the written judgment, based on the comments of the court, these are the forms which form the basis of their decision. The results are transmitted electronically via mobile devices, very much like tablet devices that you and I might use. From the polling stations, the form is filled out on those tablets and then it's transmitted electronically to the National Tabulation Center. But that's an electronic document that is sent, and of course one of the concerns around the security of these electronic documents is that they might be hacked, which has been one of the allegations made by Raila Odinga and the NASA campaign. So as a safeguard to protect against the potential of hacking and the changing of electronic signatures and changing of the electronic forms, 34A and 34B forms were completed in manual form, in paper form, at the polling station and were signed by all of the political party agents present. So those forms form a manual proof of the results, because if the results between the form and the electronic form submitted do not correlate perfectly, then there can be a query about the legitimacy of that result in the system. And that's where the number of 569 polling stations where no forms have been received has come in. So those forms are very much a safeguard to protect the integrity of the election, and the fact that so many polling stations are missing those forms has raised concerns about, can we trust these results?
Well, I think your question, your answer is following what I read from the electoral regulations. The election regulations, Form 34A is a form used to tabulate the results, as you said, of the presidential election.
Exactly.
It is filled by the presiding officer after the counting of votes at the polling station. It contains details of the votes garnered by each candidate and then details the number of registered voters in that station, the rejected votes and the objected one, the disputed and the valid ones. And these are the forms. These are really the forms that Chebukati is referring to, that these forms were missing, and he puts the blame squarely on CEO Chibula. Dr. Rupia, you can join us in this discussion. Probably you are more familiar with what we are talking about too.
Yes, certainly. What we are referring here is that there is a backup system, manual system to the IT. And what Wafula is mentioning in his leaked memo is that of the 12 items that he cites, he also includes the missing or the irregular or the absence of either Form 34A or 34B. Now, he as chair is alarmed at this development, and he is almost ordering the CEO to answer each and every of the 12. The other 2 points that we must take into account, to me, is that there have been 6 officials already removed from the IEBC, at least 1 or 2 of them being security officials from the president's office. And this was one of the 4 items that Raila Odinga had said, look, if we don't address these issues, then I'm not going forward with the elections. The second is, I think, a very general issue with all African elections. They have asked to have access to the voters' roll. And that's one of the items that I think the IEBC has to have its act together before we go for the second presidential runoff. Certainly, when these things are addressed within Kenya, it will strengthen the integrity and democracy going forward. But we have elements here that speak to other African elections as they also occur.
Well, yes, I think these elections have great implications for the rest of Africa, because although this was the case in South Africa has always done the elections close to enough. But one of the things that concerns me, as Dr. Rupia was saying there, is that Wafula Chebukati is absolving himself from the problems, because he must take accountability, as Raila Odinga is saying.
Yes, I think we need to contextualize, and I think Justice Crickler made an important point, that it is a very thankless task being the chairperson of an electoral commission, in particular when the results of that election are heavily disputed. And of course there is so much on the line in any election, because we're talking about power and in many cases access to resources which many people are prepared to use all sorts of dirty tricks to try and attain. And the electoral commission and the integrity of the electoral commission is really critical in being one of the institutions that can be trusted in such circumstances. Of course, the courts are another critical institution in determining how trustworthy was the Electoral Commission. But in this case, we need to remember that Chairperson Chebukati has been in his position for less than 7 months. He is a new chairperson. He was the new chairperson brought in after the opposition went to the streets in 2016 and protested and actually removed the old commission, which at that stage had already begun to prepare for these elections. The CEO, Ezra Chiloba, was a remnant from the old commission. And he kept his position, and the new chairperson agreed to work with Mr. Chiloba. And of course, it seems that now that there is a blame game based on the Supreme Court's judgment, now everyone is pointing fingers at everyone else, and no one is prepared to accept their portion of the blame.
One of the issues that was raised, I read in my research for this program, was that the opposition is saying they got information from somebody inside the commission, and one of the commissioners being fingered by the Jubilee Party as being the mole in the commission.
You know, I think that these are type of the dirty tricks that I was referring to. You know, you have seen leaks, you have seen allegations of documents that prove hacking. I've seen all kinds of conspiracy theories happen. You know, as an observer on the ground, we really had to be very careful what information we trusted during the pre-election period. I remember there was an incident where after Chris Msando, the ICT manager, had been found dead, there was a very fertile environment of conspiracy theory that other people were being targeted and were also being killed off. And one particular army general was named as being one of the persons who had been killed in this purge. And then, of course, 5 minutes later, he appeared on TV and said, "I see my name in the media that I have been killed, but I am here." So there was really a lot of misinformation, a lot of rumor, and a lot of fake news that was doing the rounds in Kenya. Yes.
Judge Krichler, I want to come back to you. I would like to talk about the dissenting judgment by the two judges, Lady Justice Njoki Ndungu and Justice Jackton Ojwang. In their dissenting judgment, said that the petitioners failed to prove claims that the polls were rigged in favor of President Kenyatta. But let me come back to how important is a dissenting judgment?
Dissenting judgments are always important. The judges are free to express their views. One cannot at this stage evaluate the quality of the majority or the minority judgments. One can only do that once one has seen the reasons, and I don't think there's much point in trying to evaluate who is right and who is wrong in the absence of those reasons. They have expressed very firm views, and one can anticipate that there will be very persuasive reasoning given on both sides to support their diametrically opposed conclusions.
Is it not right that, I understand that even though the dissenting judgment does not make part of the judgment of the majority, scholars will always go and quote a case law from a dissenting judgment?
Oh, certainly. But just hang on a second. We're talking about a decision here that is redolent with political implications. In this particular case, and as in all electoral dispute cases, the issue is politics, it's power, it's access to resources. It's much more important than merely law. And the disputes that are based in law in electoral cases are very, very few and very, very far between. Largely, we will find the difference being an interpretation of facts. I read the facts this way, you read the facts that way. I don't think that we can expect any great jurisprudence to emerge from this particular judgment, but one can wait and see. It may be so. I would be surprised, though.
Dr. Rupiah, without casting any aspersions on the judgment by Lady Justice Njoki Ndungu, apparently Justice Ndungu was one of the judges who actually dismissed the petition of the opposition in 2013.
I don't think we should, Dumi. This is how courts work. They always, defer to the majority decision. Certainly, the views of those dissenting are also taken into account, but because they are in a minority, the majority, question that, then takes effect. And this is what has happened in this case. For me now, I think, is how do we concentrate on the factors that are on the ground going forward? What does this mean to the Jubilee Party and also to NASA? One of the characteristics, to me, that is worrying in Kenya is that these are coalition political parties. Many of them not based on clear principles, manifestos that distinguish one coalition from the other. And there's also, of course, the ethnic dimension, which we need to take into account. So going forward, whether or not the incumbent president or president-elect is returned to power, or whether or not Raila then wins the election, this may seriously leave the whole society or country of Kenya seriously divided. Kenya is located in the Horn of Africa, one of the most volatile regions on the continent. We have instability, in South Sudan, in Eritrea, all around the region. And Kenya had been, a core of stability. So going forward, we really have to begin to understand the implications of this court's decision and the elections.
The issues raised by Dr. Martin Rupiah there is something I heard I listened to a colleague of mine in the United States yesterday, Sherwin Bryce, doing an interview with the Secretary General of the United Nations. And one of the things he is talking about, should human rights be or wrongdoings be overlooked because we want peace?
I think if you start on that particular train of thought, it's a very slippery slope. Because very often the ignoring of human rights is what brings out the worst in us. When human beings feel as though they are not being valued, not being looked after, in fact when they feel they're being oppressed, then that typically leads to far worse scenarios. So I think that the argument that you need to look the other way when human rights have been abused in the interests of some kind of greater good is a very slippery slope. It doesn't tend to work out in the long run. You might get short-term expedient results, but in the long term I think that some of the examples that Dr. Rupiah referred to in Ethiopia and Eritrea are good examples of just how over time the consistent repression of human rights leads to additional problems that become even more intractable to solve.
The other thing, Raila Odinga and his coalition have asked for certain changes to take place in the commission. And will those things, listening to Chebukati, it doesn't seem that is going to change. He has weeded out those people he says were doing wrong things, and he's going nowhere.
I think that this is a question that can be applied to the entire election. As we've already said, there are 60 days within which the new election needs to be held. It's not likely that it's going to be held under a new electoral commission because the courts have already ruled in the pre-election period on the processes that need to be followed to replace the commission, and there isn't time to do that, to replace the commission at this stage. And I think similarly the question needs to be applied to the entire election. So if we are having the same electoral commission, the same actors, the same Kenyan electorate, and arguably even less ideal conditions for a conducive and trustworthy environment for the elections, what is going to change next time around?
Justice Krichler, let me ask you one final question on the issues around the judiciary. It would seem to me this election and the decision of this court has taken the whole of Africa by surprise, and any other court will gain credence or will be emboldened by this decision. Do you think so?
I don't think it's all that earth-shatteringly different. The Supreme Court in Sudan, not Sudan, elsewhere anyway in the region, has in the past ruled an election of the president to have been illegal. It only did so several years later and said, well, we can't make an order because it's too late now. So the fact that a court has held a presidential election to have been illegal and therefore invalid is not unique now. It's been done before. It will be done again, I trust, in a situation where the country can progress from there. I want to make a point, though. The success of an election depends upon the attitude, the climate, the political mood of the electorate. If the electorate is in conflict, if the electorate is looking for trouble, an election cannot resolve it. We in 1994 showed, and I trust we will show in 2019 again, that we want elections to work. If you don't want elections to work, you can always upset them.
Dr. Rupia, some analysts raised another concern. They are saying if the election process was flawed to such an extent that there should be a rerun of the presidential race, these were general elections. Why not the whole elections be rerun? Why only the presidential race?
You are right in raising that question, and of course, people like Judge Johan Kriegler, you have been on the ground trying to help the Kenyan process, to go forward. I mean, we need, before I respond to your question, we need to recognize that there are some good things that we are seeing at the moment. In terms of the petitions, the reforms in the Constitution, the reforms even within the IEBC from the KFC, previously, the petition that has to be in place within, a given period, all those things are good things. But certainly, to go back to your question, I think it's important to take note that the losing political opposition before, after the August 8 election, set themselves down. And in spite of the comments that were coming from the various election observer missions, from the African Union, from the Carter Foundation, from the Commonwealth, etc., they set themselves down and tried to isolate clear areas that were flawed in terms of how the election had been conducted. And this is what they submitted to the courts. So I think we must not lose sight of the positive elements that are emerging in this particular crisis. That, of course, I think will also can be extrapolated to impact positively on other electoral forms on the continent as we go forward. Elections on the African continent is a modern post-2000 phenomena, and many countries are still trying to find and to refine how best they can go forward, with this political succession. It's a major battle.
Grant the elections are taking place on October the 17th. Is that enough time? Should the elections be pushed further back towards the end of the 60 days?
I think that the IEBC will have made a determination based on what they know and what their systems believe would be ideal. When you set a date for an election, there are many factors that come into it. The weather patterns are important because access to far-flung areas of a country as large as Kenya is important. Also, if it is expected to be the rainy season, that can also impact on voter turnout. So there are many elements at play when you select a date. It might be tempting to just take the maximum 60 days, but irrespective, there's no doubt that 60 days, which is the constitutionally mandated time within which a new election must be held, is a very short turnaround time. And if you have less time to correct the mistakes that the Supreme Court feels that you have made in the election, because we're only seeing the judgment next week, then of course the time frames become even more pressured.
It becomes very short, because he himself, Chairperson Chebukati, says key among the things he's supposed to do is recruitment of electoral staff, training of that staff to avoid another bungle. Also, he is to focus on the ICT, a sore subject for them after the Supreme Court found that their transmission of the results in the August 8 election was wanting. Wafula Chebukati has also insisted party recruits well-versed in technology to prevent similar. They want party officials who are well-versed in technology so that to be part of this so they can avoid a similar thing. But I seem to think that Raila Odinga is demanding nothing less, the removal of this commission.
Yes, he's on record as saying that he doesn't trust the current commission. And I think that we need to recognize that what the judgment has not said, while they have said that there were procedural irregularities, they have not said that this election result itself was not credible. They stayed away from that because I think that would be a political statement that the Supreme Court felt uncomfortable with saying. So if the IEBC can correct the procedural irregularities to the satisfaction of the Supreme Court, and as Justice Kreitler repeatedly points out, to the satisfaction of the Kenyan electorate, then we can have a positive outcome to these rerun elections.
Final word from you, Dr. Rupia. Should we expect a fair and free elections?
I think I need to address the points that you raised on why is it only the presidential runoff and not necessarily the 6 posts that were being run. The election that has just passed had national election, presidential election, senatorial, governors, etc. But the petition by the commission, by the losing party, was only for the presidential election. And I think the court then confined itself to ruling on the presidential runoff rather than the whole election which had been run. Certainly, I'm looking forward to the people in Kenya finding themselves and reconciling and running an election and going forward. Of course, there will be more transparency and introspection into how the IEBC conducts itself, but I'm hoping again Kenya becomes the lead nation to provide us with stability based on clear, free and fair elections going forward.
Well, probably it's good to have a final word from Josh Krichler. Josh Krichler?
I want to agree with my two colleagues. It is crucially important that the people of Kenya have confidence in this new exercise in October. In asking for that, one relies very largely on the political leadership, on Raila Odinga, on Uhuru Kenyatta, on their party leadership with them to ensure that the people of Kenya feel that they are being given a genuine opportunity to express their will for the future governance of their country.
Well, gentlemen, thank you very much for your time. It's been a riveting discussion, but it would seem to me we are not going to solve the problems of Kenya here in the studio and in Pretoria and in Cape Town. We'll have to wait for October the 17th when that election will be rerun. In a paper on the Kenyan 2010 Constitution by Professor of Constitutional and Human Rights Law at the University of Cape Town, Professor Christina Murray, she says, and I quote, "Finally, the Constitution relies on an active citizenry and provide multiple opportunities for the public to hold the government to account. The rights to vote, free speech, free media, and access to information constitutes that foundation." This has been Rights and Recourse. This program is repeated on Monday morning at 5 o'clock. From all of us in the studio, thank you to our guests and good afternoon.